David Sager focuses on high-stakes litigation at Lowenstein Sandler. He is recognized for his expertise in franchise and distribution matters, where he represents many global brands. Today, David will discuss litigating post-closing claims for indemnification, breach, and fraud arising from stock and asset transactions, and how trial lawyers can team up with deal attorneys to improve a client's position at the drafting stage. Please welcome David Sager.
So before we start on the fraud issue, I wanted to follow up on Joe's issue just a little bit, and we coordinated for just a moment, and that is the case that has gotten most general counsel's attention this year in the cybersecurity arena, other than Ashley Madison, is FTC versus Wyndham Worldwide. I have had the privilege of representing Wyndham for about 20 years and its predecessor corporations. I do not represent Wyndham in the FTC case, but perhaps I have a little more insight because I work with the company almost daily and their outside lawyers. And I just wanted to point out for general counsel in the room, a lot of the articles I see written about the case are in fact wrong. I would say about 80% of them are wrong, and they say it's a new world order, the FTC is coming, Wyndham has lost. And Wyndham lost a motion to dismiss. Wyndham didn't lose anything in the case. What's really at issue, what general counsel I think really should be worried about in that case, is that the FTC has not developed a general law on data breaches and what level of security and reasonable preparedness is necessary to insulate a company. And what is being debated, or was debated before the Third Circuit Court of Appeals, was just that. Which standard's going to apply? And if I'm sitting in a general counsel's office, what I'm worried about is these cases are going forward, but no one really knows what the standard is that you need to meet to protect yourselves. So if anybody has any questions about the FTC case, Joe and I are both available to talk to you about them, and we can direct you to some articles I think are a little better and better informed. So now to the topic at hand. I've spent a very long portion of my career representing fraud claims, and they arise in a variety of instances. Environmental representations in conjunction with asset deals and stock deals, earnings representation claims in conjunction with hotel acquisitions and long-term franchise agreements, claims resulting from defective products, one involving pipeline products that were compared to a Bhopal, India type of risk, and many others. And the reason I use this and open with a Spinal Tap slide is really because everybody loves Spinal Tap, or should, and because the one case I had lasted 11 years. And it lasted 11 years, we never got to the summary judgment stage. So these cases that I've handled tend to last a very long time. I've had them last 5 years, 7 years, and the longest, again, being 11 years. And in those 11 years, they take up lots of company time, company resources, and are very disruptive to businesses. Rarely is a transaction so profitable that a business doesn't mind litigating it for several years and spending millions of dollars. So that's the topic today, is we know these cases, or these cases are filed, these claims are brought. Ellis actually sent something to me just the other day confirming that it still is one of the most prevalent areas of litigation. They're happening all the time, and the question is why, and what can we do to help our clients avoid and defend them? So let's start with the why. Why is it that there are so many of these claims that are filed? And there are lots of answers. This list is not, doesn't cover them all, and there are lots of nuances to the ones that are here. The amounts at stake are large. We're often talking about 9-figure deals. Markets change. The one I litigated for 11 years had to do with oil and gas pipelines. The price of oil plummeted immediately after the acquisition. Go figure, we were sued for fraud. Executives change. In that case and in others, you get a new senior executive might disagree with the deal parameters, with the deal, the basis for the deal in the first place. And one of the things that isn't as often thought of, but in my experience colors these things more than anything else, is when you transfer your assets or your business, the buyer now has them. The buyer speaks to your former employees, looks at your former documents, has your former customers. All of the things that were perhaps a little bit more arm's length in the negotiation stage are in their lap, and they scrutinize them. But another reason that I think we wind up with so many fraud claims isn't as obvious, and that is because deal lawyers are really good. And the deal lawyers tend to limit the contractual remedies very effectively. So think about the average deal document you look at. It includes a restriction that all claims are indemnity claims, that you can't bring the claims until they exceed a certain amount of money, that those claims are subject to a cap. Those claims must be brought in a certain court or before a certain arbitration panel. All sorts of restrictions, rules, and things that make those claims, those breach of contract claims, difficult to assert and less profitable or less financially rewarding should they be successful. And so as an outgrowth of that, as a consequence, one of the things I find is that ordinarily plaintiffs' lawyers who are representing buyers in M&A litigation will bring a fraud claim. Because the fraud claim, they believe, frees them from all of the shackles of the deal document. If there's a fraud claim, we're all taught to believe, then they don't have to abide by the contractual cap or limitation or deductible. They don't have to necessarily abide by the arbitration provision or the governing law provision, and it gives plaintiffs' lawyers, buyers' counsel lawyers, a lot more flexibility. So one of the reasons we see fraud claims is deal lawyers are really good. But let's talk a little bit about what I mean by these in terms of the deal terms. Survival periods. How long can you bring the claim? Governing law provisions. What state's law is going to govern? Forum selection arbitration clauses. I've had cases where that was determinative. The fact that the case had to be arbitrated before a panel of 3 arbitrators in a remote location meant essentially that the buyer's incentive was reduced, if not eliminated, over time. It was going to take forever. It was going to be incredibly costly because on top of all the litigation expenses, they had to pay a panel of 3 arbitrators. So all these things are working to make fraud claims more appealing. The types of claims we therefore see as a result are breach of representation and warranty claims. And think about the first category as in the document itself. I say to you in the document, here's my environmental rep or my product rep. I had a problem with this product. It's limited to 10 units. You don't have to worry about it. And the post-closing claim is that affirmative rep is wrong. The second category is, I know what the document says, but don't worry about it. This business is very profitable. And that disclosure I made in the litigation section, don't worry about that. I'm telling you it's not a problem. In fact, let me show you some pieces of paper that demonstrate it's not a problem. Or, I can't make an earnings representation to you. I can't tell you what this business generates or will generate in the future, but let me show you some data, some reports that may show you just how profitable this business will be. By the way, all those are real examples of facts that led to post-M&A litigation in my experience. And then the last one, which I think is probably the most difficult to deal with, is failure to disclose and concealment. Sometimes you just don't want the other side to know a whole lot about your business. And frankly, sometimes if you're the buyer, you don't want to know. Sometimes you're better off putting your head in the sand and waiting and preserving, right? So we have to be careful sometimes what we wish for. If we're given the keys to the kingdom, we're then charged with all that knowledge. So these are the 3 general categories of claims we see. And I want to focus first on the affirmative misrepresentations. But let's focus on the affirmative misrepresentation that falls outside the contract itself. We're not talking about the rep that is a lie that's in the deal. We're talking about the earnings claim or the earnings representation that's outside the deal. We all know the elements of a fraud claim. And there needs to be a false statement. There needs to be knowledge of or indifference to the falsity, an intent to induce the other party, and then there needs to be the critical element for what we're talking about here today, which is reasonable or justifiable reliance. This is the battleground. And the way deal lawyers are attacking fraud claims and attempting to help their clients is by defeating the notion of justifiable or reasonable reliance before the deal ever closes. And again, we're dealing with the situation where somebody says, you have told me something outside the context of the contract itself that I relied on in entering into this deal. So how do they do that? And can careful drafting prevent reasonable reliance? Or as one commentator put it, does a properly drawn contract give a party a liberty to lie? The answer is maybe. And if we are effective in helping our clients, the answer is yes. The case that gets the credit for starting this whole dialogue is a case called Denan Realty versus Harris, which is at New York's highest court from 1959. And it gave rise to a series of decisions. If you look at any of the law in this area, they will almost always, in fact, I've never seen one that doesn't, go back to Denan and look at this particular quote. Denan addressed claims of oral misrepresentations in the context of a lease, and it looked at reliance in a different way. If a buyer says the buyer didn't rely, the buyer can't subsequently come back and say it did, in fact, rely. That's the basic concept. If a contract says I didn't rely, then it stands to reason the buyer's out of luck. The buyer's subsequent lie, meaning I didn't rely on anything, supersedes the seller's initial lie. Everybody with me? It's the judicial equivalent of I'm rubber, you're glue. But this case has morphed into something much more complex, and particularly in the battleground states of New York, Texas, and Delaware. And that's because a vast majority of the deals that are done in this country are governed by the laws of those states. So the law there tends to be more developed. Depending on the law that applies, sellers can prevent fraud claims, and let me show you how, or tell you a little bit about how. Boilerplate provisions, the standard no reliance clause, typically is not enough. I didn't rely on anything in this agreement, or I'm sorry, outside of this agreement. This agreement contains all of the representations of the parties. There are no representations outside of the four corners of the document. Right? That's what we've all been taught to include in documents. That's what we all typically see. But what about if the agreement said something more? What about if the agreement said, we understand that the projected financial performance of this business is relevant to the parties and has been relevant in their negotiations, and that information is shared in this document and has been shared elsewhere? And what if it further said that you have not, buyer, relied on any piece of information or data at all that you may have seen in conjunction with this deal, except as is reflected in this document, except as reflected in the deal document itself? Fortunately, I've litigated, and even more fortunately, successfully litigated that very issue. And if you have a specific no reliance provision, and you are confronted with a specific allegation of fraud, you by and large will be okay. You will defeat the fraud allegation, and in fact, there's an evidentiary issue that most of you may be thinking about, which is, does the parole evidence of this side deal ever come in the first place? In the parole evidence world, parole evidence is always admissible to interpret a deal document, except, there's a couple exceptions, but the one we're worried about, except when the parole evidence contradicts an express term of the deal. So the earnings example, I've told you, don't rely on any earnings claims. The only earnings claims are in this document, okay? And you come in and you say, but I've got this earnings claim. You may win on a parole evidence basis, but if you don't, you should win on a summary judgment anyway, because you have defeated the element of justified or reasonable reliance. So the important point to take away from this is it needs to be specific. You need to think about where the disputes, the post-closing disputes, are likely to be, and you need to try to address them. Now, the other side's not going to roll over on this. They're not going to just say, okay. But for in-house counsel, the more you can get into that deal at the drafting stage, pre-execution stage, the easier our job becomes afterwards, and the more you will insulate your business from liability. The same cannot be said for intentional misstatements in a contract. Okay? If a representation in the contract is false, what then? What can I do in the contract to protect myself? Well, there's some interesting ideas that have come up. One of them is, it says you are limited to indemnity claims in the contract, and if you bring an indemnity claim, you're limited to all the caps and thresholds that we talked about earlier. Another is, you are not entitled to rescission under any circumstance. So in the contract, we say, here are my representations are true, but if you come back and show that they were not true, you still are not entitled to rescission. It's kind of an end around to prevent the other side from opening up a deal, right? Well, the courts, despite all this advancing law that says maybe you can lie with impunity, have been resistant to adapt that view. And for instance, a Delaware court referring to this situation where there was a false statement of fact that was intentionally or alleged to be intentionally made in the contract itself, said the contractual freedom to immunize a seller from liability for a false statement or a false concealment or statement of fact ends there. The public policy against fraud is a strong and venerable one that is largely founded on the societal consensus that lying is wrong. So we're not going to reward you for being cute in your contract, and we still have the same problems you're all used to when the alleged fraud is based on the contractual language itself. Omission claims are a lot harder. But even in omission claims, there are things we as lawyers can do together pre-litigation to improve our chances of prevailing. We can include things such as, buyer, you had access to all the information you wanted. We will put that right in the contract. Buyer, here are the areas you should look at. And if you don't, you do so at your peril. We make those claims because when the buyer later says, well, hey, I never knew this, so it wasn't an affirmative misrepresentation, it was a non-disclosure or concealment, you can say, no, buyer, you represented to me in that contract that you had access to everything you needed to, and that I did not have superior knowledge, and where I did, you were free to ask for it. And if you include those types of specific provisions, once again, you may be in a much better position to avoid the litigation that plagues almost every deal, large deal that occurs. The deal agreements can include provisions about accuracy, completeness, and buyer's opportunity for diligence. And they can be very effective to defeating omission claims. So with that, I leave you with the following conclusion, that there are states in which you can effectively insulate yourself from a lie. You need to be mindful of state laws that are exceptions. For instance, in New York State, there is a franchise protection statute that says no, you cannot waive any protection of the statute. The Securities Act of 1934 has a similar provision. So you need to be familiar with state law, but if you work with your deal attorneys, if perhaps in-house counsel, general counsel, bring in litigators at the deal stage for assistance with diligence, perhaps you will better situate yourself to defend against these prevalent claims. And I thank you very much for your time.